But you could, so those are the things that you're looking for. So it's not just potentially the legal work, but that you may be able to assign the administrative. You may be assigned the ministerial. You don't have to, but it should be delegated differently. But you might have a situation that you say, look, I have to set up a special needs trust. I don't have the capacity to do that. There's nothing wrong with getting to an elder law attorney that does it all the time, that you know from the bar, and say, can you set up a special need trust? They'd be glad to do that for you. You have to have an overview of what this case is going to be. I may have given you a case that has no money in the estate. You know, sometimes there's a pension, sometimes there's not, sometimes there's Social Security. So you may end up with a case, well, there's nothing here. I try to keep that in mind later on down the road. I know Guardianship Services gets a number of cases where there is not anything in the estate, or there might be very little. So how you manage the estate is going to dictate what you bill. You may end up with a $5 million estate that is a mess. That's you're going to have a whole entirely different approach on how you bill and the work that is required. So like Dennis said, it is a case-by-case basis. Guardian ad litem is a little bit different because you are, and I do watch what you bill, but a guardian ad litem acting as the attorney rather than the guardian for the individual, you are going to get paid even though there's nothing in the estate. Now the first thing I'm looking towards is that the estate or the individual's property is enough to pay you rather than it coming out of the county. But if it's going to come out of the county, you have to understand, I'm looking at that bill. And if you're billing me dollar for dollar and all of a sudden there's nothing in that estate, and I got to stick the county with that dollar for dollar and it's a huge bill, that's going to have a big impact on what I assign to you the next time around, whether it's a guardian ad litem or a guardian of the estate. So if you're a guardian ad litem, you know that you're in there protecting this individual for the court. You have to look at how you're billing. Is there enough in the state for me to bill at everything I've done, every envelope I open, or is this going to come out of the county, and how is the judge going to look at that in terms of how he's establishing a relationship with us down the road? So I think that's a pretty frank discussion on billing. Does anybody have any questions on that? Because of course, I mean, if you're going to do this kind of work with these wily individuals, you do want to get paid. Any questions on that? I think, and for the most part, I've seen that people acting in that spirit. I've seen some aberrations, and every now and then, I don't think it's intentional. Dennis will make a phone call and have a discussion with you about it.
Yeah, we only got a minute or two. I just want to make two final comments. Guardianships sooner or later end. Most of them will end when somebody dies. You have an obligation to file a final report within 60 days of when somebody dies. That doesn't necessarily mean you're totally off the hook, because now you're holding a lot of money, or maybe you're down to nothing. So basically, your report and your accounting is going to go to the executor and or administrator of the estate, if there is any. Sometimes you will need to file a formal accounting with the court to get court approval, but many times you can do your final report, you submit your accounting and all your documents to the executor of the estate, and you should have them sign off so that they're not looking to you for anything else. In addition to that, you can always ask for a petition for review under section 5512.2, meaning the court can always, I don't want to say change its mind. Typically when you get a petition for review, it's because somehow the person has gotten better and doesn't need a guardian. It doesn't happen with people with dementia, which is maybe more typical of what we have, but a lot of times somebody will be appointed guardian because somebody was in a serious car accident, and now after a year or 2 years of treatment, they're doing better, and the court can review it. The court can always review it, so it's just a matter of filing that petition. Sometimes a petition for review will be filed because somebody has brought to our attention that somebody is not acting very appropriately as the guardian. So it may be a review to determine whether this person should still be the guardian.
That's a good point. We do have review hearings. I guess in closing, I want to thank everybody for joining us. I want to thank the bar. The elder care bar is tremendous. I think in Delaware County we're way ahead of the game in terms of trying to protect the elderly and the resources that we have in place. I want to thank Dan and Beth, Dennis, Jackie, our register, Jennifer and Carol Hershey, for participating in this program. I think it was an excellent program that they put together. In parting, what I would say to you, the one thing that we really didn't discuss is power of attorneys. We have done that in other roundtables. We'll do that again soon. You're the first line of defense. Power of attorneys are the instrument that we see that is most abused. When you go to write your next power of attorney, I think you really need to know the new power of attorney law, and you really have to make your principal understand and give your principal understand examples of, when you sign this, your agent is going to be able to do X, Y, and Z. Is that what you really want? Because they may be surprised that that agent could go out the door and, unbeknownst to the principal, that all that real estate is in the agent's name. And believe me, that happens. They may be surprised that all of a sudden their bank account all of a sudden is in that agent's name, and that happens. So the power of attorney is a very powerful instrument, and believe me, that's where we see the most abuse, and that's where I really would ask, when you do a power of attorney for any of your clients, you realize just what kind of instrument you're having them sign. I would also recommend, and it's to your benefit as well, once you have that pet, you really have to understand their assets and what they have when you're giving that power of attorney away. I would recommend that every 6 months you come back and with that principal alone, review all their documents that they showed you and assets, and review them and to make sure they understand where everything is and where everything went. That would go a long way in terms of damage control. So with that, thank you all for coming. And thanks for being here.